If the meeting could come to order, please. This is a regular meeting of the Princeton Planning Board. It's Thursday, December 3rd, 2015, and the opening statement is as follows. Pursuant to Section 13 of the Open Public Meetings Act, adequate notice of the time and place of this meeting has been given by prominently posting the 2015 agenda resolution of the regularly scheduled meetings of the Princeton Planning Board. Such notice has been placed on the official bulletin board at the Princeton Municipal Complex and is to be maintained throughout the year by transmitting a copy of such schedule to the Princeton Packet, Town Topics, The Times, Trentonian, and Comcast Media. A copy has been filed with the Clerk of Princeton on the 9th day of December 2014. Legal notice on the adoption of said resolution appeared in the December 9th, 2014 edition of the Princeton Packet. Would you call the roll, please?
Ms. Burge? Ms. Capizzoli?
Here.
Mr. Cohen?
Here.
Ms. Cronmiller?
Here.
Mayor Lempert? Here. Ms. Brule? Mrs. Trotman?
Here.
Mrs. Ullman?
Here.
Mrs. Gunning?
Here.
Mr. Quinn?
Here.
Mr. Williamson?
Here.
We have a quorum.
Thank you. Okay, does anyone have any announcements? Just wanted to report to all of you that we are working on the annual report for the planning board for this year, and as always, I'm asking all board members to email either the office or me with their suggestions for programming for next year, for improvements in how things have been running, comments on what you thought the high points of the year were. It's the drill as last year for those of you who were on the board last year, and it's a chance for newer members to give us their initial ideas or impressions. So please let me hear from you. The report has to be finished by the end of the month. Okay? Yes?
I wonder if we could review, or else if you could quickly explain the rationale for why we swear everyone in and make them swear they're telling the truth. Because it seems kind of tedious, and I always feel like, aren't people assumed to be telling the truth? I don't like it when, so I was just wondering if anybody ever questioned that or thought about getting rid of that, because I think it would be...
I think we'll ask Mr. Porter that one.
Yeah, this is a quasi-judicial process that it's administrative, but it still is based on sworn testimony. So to the extent we're making decisions, we're basing it on testimony, which is a higher degree if it's under oath. And in fact, if it weren't under oath, our decisions could be subject to challenge.
So we have to do it, in other words.
Well, there may be an issue with respect to people who are from the public who are not giving testimony, but if you noticed, I've said to the extent they're giving testimony. If they're just giving opinions, they don't need to be sworn. And attorneys we've been swearing in because they often lapse into testimony.
Okay, thanks.
Okay, thanks. The rest of you, if you have questions like that and are too shy to ask them at a meeting, now's your chance to email them. Okay? All right, other than that, you've had in your packet some findings of facts. The first set was RB Homes Incorporated. This is from September 28th of this year. And let's see, this was a subdivision committee meeting, and Ms. Capizzoli, Ms. Ullman, and myself were there. So were there any emendations, corrections, anything? Either of you?
No.
Okay.
I move to approve.
I second.
Okay, it's been moved and seconded. All in favor?
Aye.
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 Oops.
Do we have to do anything?
The next set of findings is also a minor subdivision, and it's PSC 2 LLC. This is from October 19th of this year, and again, it's Ms. Capizzoli, Ms. Ullman, and myself. Any corrections, additions? No?
I second.
Okay, all those in favor?
Aye.
Right, and the last one, which I think was distributed separately, is Avalon Princeton LLC and AV Princeton Homes LLC. This is from October 15th of this year, and this is findings of facts and conclusions. Any additions, corrections? Yes, Jenny?
I was wondering, on page 3, when it says that the staff recommends a conservation easement be placed on that one lot, is that the municipality? Who's going to own the easement? The municipality? And should we include that if it is, or?
It hasn't yet been submitted because this hasn't yet been implemented. Clearly, the municipality will have the right to enforce it. It may be a restriction that is imposed on the lot owner, which is typical, but if it's that the other people impacted by it have a right to enforce it. It's not a deed to the municipality. It's often when restrictions are placed on property, it's done by a deed from the property owner to the property owner, and it's then a binding restriction that passes when it's deeded. So, and if, depending on the type of restriction, there would be other people, including the public, that would have the right to enforce it.
We did discuss this at the meeting, and it seems to me that the conclusion was that it would probably be held by the applicant, but this was to be determined in the end.
By the landowner.
Yeah. So,
When it's submitted, I'll pay particular attention to that question.
Okay, I mean, because if it's the landowner, what good is it?
I'm sorry that this is not a public part of... Okay, this is not the public part of the meeting.
Okay,
Or you could sit closer to the... Okay.
okay, so it seems like it might be important in the future that we make sure that the public has the right to enforce it. I guess I just want to make sure that's clear.
It's like a zoning restriction that if it were violated, the zoning officer would have the right to enforce it.
And is it recorded in the deed, or
Yes.
in the deed?
And maybe a separate restriction that gets filed in the county clerk's office as well, like a deed. So anyone searching title would find it. The next owner would know about it and be subject to it, and it would all be known.
Okay.
Okay, so are there other corrections, emendations, additions? No? Hearing none, could I have a motion?
I'll move it.
I'll second.
Okay, it's been moved and seconded. If there are no further emendations, corrections, all those in favor?
Aye.
Aye.
Opposed? Carried. All right, now you have two sets of minutes. One is the special meeting of October 29th. And I think there's not a whole lot we can say about these minutes.
I'll move it.
Okay, is there a second?
Second.
Okay. All those in favor?
Aye.
Opposed? Carried. And the other is the special meeting of November 16th of this year.
I'll move it.
Is there a second?
I'll second.
Seconded. All those in favor?
Aye.
Opposed? Carried. All right, that brings us to this evening's discussions, and the items are all ordinance referrals, and I'm going to ask Lee Solo to walk us through these. Should we go one by one, or? Yes. Ms. Clerman, can you hear now, or? Okay. Okay. Mr. Solo?
Okay, I'll take each one in the order that they appear on the agenda. The first one deals with land use fees. Currently, there's a conflict between the land use fees in Chapter 2, which is the new combined ordinance, and in Section 10B36, which is the former township ordinance. The proposed ordinance that's before you simply corrects that conflict. I don't know if there are any questions on it. It's pretty much administratively. We discovered it when somebody was looking at the fees and saw that they were slightly off.
Okay, and these are all here for compliance?
For the board to find comment and to find consistency with the master plan. There's not a whole lot of master planning with the fees, but if you want to recommend the adoption to council, that would probably be the appropriate thing.
Okay. Anybody have any comments or questions on this? Somebody like to propose that we recommend the adoption of this ordinance to council?
Gail Ullman, I so propose.
And there's your second.
Julie Capizoli, I second.
Okay, all those in favor?
Aye.
Okay.
Can I just...
Thank you. The second ordinance deals with A-frame signs in the downtown business districts.
Lee, can you hold it just a minute? I'm sorry. Mr. Porter?
Yeah, we have a group of these, so just so we're clear as to what we're doing, the municipal land use law provides that when a land use ordinance is introduced by the governing body, it needs to be referred to the planning board, if there is a planning board, and we have one. And the planning board's role is to, among other things, determine consistency with the master plan, and otherwise, if there are other issues, to make comment. So that's, as Lee explained, they're here for the board's review and recommendation back to the governing body.
Okay, sorry, please continue.
Okay, thank you for the clarification, Alan. Also, Derek and I did prepare for the board a November 24th joint memo that sort of outlines what I'm going to be talking to you about with each of the ordinances. The next one deals with A-frame signs. Currently, A-frame signs are permitted in the downtown business districts with little regulation other than that they be temporary, meaning 14 days, and that they advertise specials or menus. From a staff perspective, it was often difficult to enforce the existing provisions simply because we never knew when the 14 days started, and whenever we would issue a violation for the 14 days in any one period, the sign would vanish for a day or two and then come back. Similarly, the specials weren't always specials, so we thought, we met with the merchants. This also comes to you via the council's code review committee as well, and after meeting with the merchants who indicated that they found a lot of value in the signs to them, that what we decided would be the best course of action would be to create some regulations that would address some of the concerns, mostly dealing with the size of the signs, their placement, and making certain that they're safe. So what the ordinance does that's before you, it would permit one freestanding sign. That sign can be up during business hours for each business located at a street or basement level in the RO, RB, NB, CB, and SB zones. And those are basically all the zones along Nassau Street, with some of them going down Chambers and Witherspoon a little bit. But it's the core of the downtown. It limits the height to 4 feet and the width to 3 feet. It indicates that all signs must be a maximum of 4 feet from the building facade that it's advertising. So there's a linkage between the sign, what's being advertised hopefully, and the building or where the business is located. It provides that on Nassau Street there be 6 feet of unobstructed sidewalk, and on other streets it would be 4 feet. And then finally, there's some language that the sign not create a danger or hazard to pedestrians. Currently, as I said, there are no standards. It's just you're permitted to sign, there's no size and whatever. We also, in talking with the merchants, heard some comments about, well, what happens if a couple businesses wanted to use one sign? And there is a provision that if up to 3 businesses want to get together, they can have a sign slightly larger, 5 feet high, 3 feet wide. Again, it would be located within 4 feet of the business, and it has the same regulations regarding sidewalks and safety. And then finally, the ordinance provides for an administrative review by the zoning officer issuing a zoning permit where he would require some sort of at least conceptual design of the sign and site plan to ensure that we have the clear area, because what we were finding is a lot of the signs are in the middle of the sidewalk, and when it's a busy pedestrian day, everybody has to sort of walk around it. Bringing it closer to the buildings would also avoid having the signs located in the middle, and then the size regulations we thought were reasonable. Most of the signs that are out there are probably 3 to 5 feet in height. I think the ordinance is a fair one. We did meet with the merchants at introduction. I don't think we had many merchants speaking against it. I don't know if there are questions from the board members on the A-frame signs. I guess there are.
Okay. Mildred was first.
I might have missed it, but did you say then, does this eliminate the time period, 14 days? So
Yes, it
that's
does.
fairly out. And even in those streets that are narrower than some of the wide streets on Nassau Street, it does allow you to have a sign and pedestrians enough room to get around, because we used to get a lot of complaints about that, so.
Right, we thought it requires along Nassau Street that you have to have 6 feet clear, which seemed a reasonable number. I think the sidewalks vary, from 8 to 20 feet even. So 6 was a minimum, and we felt that allows at least 2 people to walk without having to get out of each other's way. And then the 4 feet on the other streets may mean that some of those merchants won't have signs because they can't provide the 4 feet. But along Nassau Street, we were pretty confident that most places could provide the minimum of 6. The other factor is by requiring that the sign be within 4 feet, and it's only going to be 3 feet wide, it's pushing it up against the building a little bit closer, because we found a problem with the signs being in the middle of the streets, especially on nice summer days, and people just have to walk all around them, and it blocks the sidewalk. So we're trying to locate them closer to where the business is and get them out of that main pedestrian way.
Thank you.
Okay, Ms. Ullman?
I have a sort of a mild question or comment about the term downtown, which is what you use in this, although you're actually describing zones that cover East Nassau Street.
Mm-hmm.
And I'm also assuming that it covers the Jugtown area, the Harrison and Nassau Street
Correct.
business section, and would it cover the that little area on 206 just off of Valley Road? So that's not
It
considered?
would not.
It's not. I mean, I wonder if downtown is it's sort of what you're thinking about, but there are business districts
Beyond.
throughout, and I would also say, incidentally, that where you have these signs at intersections or near intersections where cars pull up and have to look up and down Nassau Street, particularly now as Nassau Street's getting worse and worse in my portion, having an A-frame sign can impede your line of vision down the street. So it's also a big issue.
I think one more down here, Wanda.
Written into this is we continue to use the terms sandwich board and A-frame. Would this apply to all freestanding signs? Was there a discussion? Because a lot of these advertising signs now are sort of single pole weighted at the bottom with
Yeah, that would
So
be
they're
permitted.
taller than 4 feet, a lot of them.
Some of them are, with this ordinance, they will no longer be.
Okay. And my other question was there discussion about requiring merchants to remove these signs during, say, high winds or different weather considerations where the risk of blowing over and...
We didn't put that in as a specific requirement. If you look on page 2 of that ordinance, we did put in a section on safety and stability. The sign shall be kept orderly, safe, and upright at all times that it is displayed, and not create danger or hazard to pedestrians using the sidewalk, and then removal of it. So we put in some general language, so we have a hook if we needed to say something. It's not a work in progress, because I think they're good standards, but what we're doing is taking the existing ordinance, which allowed the signs in the zones that we're currently recommending again, and then place some additional restrictions. I think Gail's comment is a good one. We may want to look a little bit closer at whether we need to, in the future, adopt and make some other changes. We were just trying to get something in before the end of the year at this point, and we could look at that. The problem is, if you go by a weather advisory and it says high winds, and there isn't, and we really don't have the manpower to rush out on Nassau Street and start telling everybody you got to take your sign in.
Okay, David, did you have a comment? No. I had a question about tethers for these signs, that occasionally people have them fastened to the building, and it's a trip hazard.
There's, again, other than the general safety provision, we didn't
Yeah,
I remember seeing many, not that I'm sure we might have missed some, because some of the signs that are up there, honestly, are really quite flimsy, and they're really indoor signs that somebody's placed outside.
Right,
We're hoping, over time, we can take care of that as well.
I think either these are to keep the sign from straying into student rooms or something like that, but to keep them safe so they can be brought in at night. But I was curious, you didn't discuss that with the merchants at all?
That did not come up, no.
Okay.
Wanda.
Yes, Jenny?
I think that those two things might be something worth talking about, but we could probably do that at the council meeting, saying something about tripping hazard.
Yeah, I think...
Maybe adding that, and also just something like during adverse weather, especially during adverse weather, or something like that, in the safety and stability section.
Yeah, when we forward the board's comments, we could put in the comments along those lines.
But, Gail, the one thing that's going to help with what you're talking about is that they have to be right next to the buildings, and so they won't be allowed to be on the corner. I think that one sign on the corner on Chambers,
Yes.
I think that the Borough Council gave that sign a special variance. Do you remember that, Mildred? But they've changed it. I mean, they showed us the sign, and they said exactly where it was going to be and how big it was going to be, and now it's different.
You're absolutely right, and I was thinking about that when Gail asked her question. It just came to me. There was that was kind of a special circumstance that sign was there. But that is placed in a danger zone at times, and pedestrians, because I happen to go up Chamber to try to get to wherever I'm going, and pedestrians sometimes are on either side, sometimes is pushed to the very corner. I mean, it doesn't stay in one spot for whatever reason. I don't know how the ordinance would cover that, other than, having Derek go out and pick it up one day.
That sign was approved by council. Derek
Yeah.
just advised me that it meets what was approved. It didn't change. Maybe the colors did,
Well,
but
the location of the sign.
location
it's not
and the
in same
size were
spot all
approved
the
by Borough
time.
Council.
But
We'll double check, and if there's interest in council, I guess you could remove that approval. I don't know how what exactly, I wasn't involved too much in that one.
I'm not suggesting that you move it, but that maybe, Derek, if you could take another look at it, because I do go by there quite often, and it causes a little disruption, and that is a dangerous intersection anyway.
So I have a question about that sign then. So would this ordinance take away that special exemption, or are there other special exemptions for signs that?
No, I mean, that was approved by council because it had the name of like 5 or 6 different stores on it, so it didn't meet the spirit of the older ordinance, so I think that would still remain in effect, and the position was close to the curb, so we'll look at the site triangle and see if there's an issue with that.
Okay, let's see, Alan reminds me that we need to let the public speak, and we didn't have public input on the first one. Was there anyone here to speak to the fee structure? No? How about this particular ordinance? Would someone like to speak to that? No? All right, hearing none. And if there's no further discussion, would somebody like to propose that we send this back to council?
I move to approve and send back to council.
I second, Gail.
Okay, it's been moved and approved, and Mr. Solo has the comments that we might want to add to it, or Ms. Quirmiller has them. Anyway, all those in favor?
Aye.
Opposed? Carried. Okay, the next,
The third one deals with exceptions to lot sizes, and this comes about as part of the, looking at harmonizing both the former borough and township ordinance. Currently, the former borough ordinance at 17A, 373A, permits developments on existing isolated lots without the need for a variance for lot area, lot depth, and lot width. All the other bulk requirements, the side yard setbacks and the height, must be complied with. But if there's an existing lot, I think it's tied to 1968, and it's surrounded by other developed property, they don't make them go to the zoning board, because routinely the zoning board grants those approvals simply because they can't increase the lot area because they're surrounded by other lots that are developed. Similarly, the lot width and lot depth is often locked in. The township does not have that provision. The zoning board reports that currently they're dealing with 1 or 2 applications a month of the former township properties for variances, and they are routinely granting these because if they didn't, it's akin to almost a taking if they say you can't use the property. So the zoning board and the staff is recommending that the former township ordinance be amended to include this exception, and again, it would only apply for lot area, lot width, and lot depth for pre-existing lots in the community. I don't know if there are questions on that one.
yes, Ms. Ullman?
This is not so much a question as it is to say that, as Lee points out, or the ordinance itself points out, the next 4 ordinances were reviewed by the Zoning Amendment Review Committee before they went to council, and I just, when you go through them, Lee, if there are any changes from that earlier, if council made changes, it would be helpful. I tried to compare them back and forth and didn't see any.
I don't think there were many, but I'll think about it as we're talking.
It would be great to have them called to our attention. I don't have any problem with this.
Okay. Yes, Mr. Kern?
So I had a question. Some homeowners on Mountain Ave had come to me with questions about the ability to use, they had 2 adjacent lots, both of which were substandard for the zone, and they wanted to develop the smaller lot, which was unbuilt. And when they went to talk to Derek about it, my understanding is that there's some kind of a state law that says if you have 2 adjoining lots and one of them's undersized and they're owned by the same entity, that they're treated as one lot from the purpose of zoning. There were still 2 lots on the tax map. There were 2 deeds for these 2 properties, and I'm just curious whether this ordinance change is going to create a situation where they would be able to develop their smaller lot, or because of this state law that sort of treated them as a single lot, does that
contradict the provision in the ordinance that says that it had to be continuously existing as a separate lot from 1968 until the present.
Let me first address the question of what's known in the case law. It's not statutory law, it's not ordinance law, it's case law, and it's the doctrine of merger. And what the courts have said is if a lot owner owns two contiguous lots and it's in the same ownership, then notwithstanding that it's a separate tax map lot.
What about a separate deed?
Separate deed doesn't matter either. Purchased at different times, if they were well advised, they would have purchased them in separate ownership. But notwithstanding that, the case law talks about merger. Now, there's some exceptions, perhaps when corner lots or back-to-back lots in the case law. So that's the background. Now, the question that you raise is something I think we talked about as well, as to whether how this ordinance impacts the merger doctrine.
I think it speaks to isolated small lots. I mean, I think if two lots are contiguous and they're both non-complying, they're subject to the merger doctrine.
I mean, I would like to suggest that in the interest of, smart growth policy, trying to develop in town rather than sprawling, and trying to, meet our need for affordable housing, not affordable in the legal sense, but affordable in the sense of less expensive. To have these smaller lots developed is actually a positive thing, and if there's a way to permit a lot like this to be developed when all of the other bulk requirements are being followed, that it wouldn't be contrary to the goals of the town as I understand them today.
But what's the definition of smaller lot? What you're talking about?
It's smaller than what's mandated for the zone, but there are many lots on this street that are smaller than what's mandated by the zone. In fact, almost all of the lots are less than half the size. It's a 2-acre zone, and if you're familiar with Mountain Ave, most of those lots are half-acre lots or so. It could be reasonably developed. It's big enough that it could be reasonably developed consistently with the other houses on the street.
Yeah,
But I wouldn't, would that be would that be considered smart growth small lots? By what it seems like.
I think it would. I mean, you're using existing infrastructure, you're creating additional housing units. And
If the board wants to forward along a comment like that to council, that may change really the intent of what this ordinance was, which was really geared towards saying, why have a property owner or a resident come before the zoning board for a variance that they're routinely granting anyhow? What you're really talking about would be changing a little bit, because as Derek said, his interpretation would be they still would need to go and get a variance or deal with our subdivision as part of the merger. So this was really put out there as not to encourage small lot development, which is what you're saying, and it's a separate issue, and if the board wants to forward that along to council, I think that's a substantive change, and they're going to have to debate that. This was seen more as both for the zoning board, which is dealing with applications that could take anywhere from a half an hour to an hour each, and then they're routinely granting it to clear that agenda, as well as to not have the property owner go through that process.
Yeah.
And the board doesn't have a lot of power to deny them anyhow. Alan, you want to?
I think that, Derek, you mentioned that this was intended for isolated small lots. I think the problem is it doesn't say that. Does it? I mean, so this would not, if it were, that's how it would be consistent with the merger doctrine, because there are a lot of competing policies. The state law policy as to zoning is to bring lots into zoning compliance, and that's really where some of the merger doctrine was founded. In addition, a lot of the small lots were created by under the old map filing law, where you could just file a map in whatever size, and in some places there are just multiple really small lots, and over time they've gotten developed. But that's really where the merger doctrine, those original cases, one of them even has a name that I remember, but I don't know why I remember that. Lechner versus Campoli, right, Chris? There's a small lot map filing act.
Yeah. The one other comment I would make is, as you pointed out, if they'd gotten advice to purchase one lot under their own name and one lot under an LLC, there wouldn't be any merger issues. So it's essentially a technicality that allows the merger to happen, and it seems like sort of an unfair imposition on owners who didn't get good advice when they were purchasing the properties versus people who did get good advice.
But most of the merger lots were purchased together. I mean, it's unusual that two small lots are purchased separately. I mean, that's not unknown, but not the usual case. But I think this really, if it's about isolated small lots, which is what the discussion was, then it should say that. And then the merger doctrine and how you deal with small lots where there are more than one lot that is a separate issue, maybe a separate ordinance.
Yeah, the language that you have in front of you is identical to what the borough currently has. So if you want to recommend that it should say the isolated small lots, that's fine, but I think that is a substantive change, and they're going to have to redo the ordinance.
Yes.
I just have a question about the process when something goes before the zoning board. I know when we hear an application for the planning board, we can grant approval, but with certain conditions. And is the zoning board able to do the same thing? And would that be a reason to have these applications go before the zoning board, even if they essentially have to grant the ability to build something that they could put conditions on it if there's concerns from the neighbors?
It depends, because usually those conditions that the planning board imposes are directly related to the application. So if they're asking for a variance for a setback, sometimes we say shift the house or do something. There's not a whole lot they're going to be able to do because, again, the property is locked in. I don't know, Derek, you can maybe speak better. Does the zoning board...
Well, a lot of times there's legal they're not legally required to present plans if they just have a small lot. They say they're going to comply with all the bulk requirements, so the neighbors come in upset that there's a house being torn down in their neighborhood or a lot going to be developed, and there's really no details for the board to look at or the neighbor, so it's just kind of an exercise in futility. So.
Yes, Jenny?
Well, yeah, I have a follow-up on that. Some people have been asking me about that. Why doesn't the zoning board, doesn't it have any leeway, because they don't have to demonstrate that there's no negative impact?
In this case law, I believe there's case law that they don't necessarily have to present house plans for just a small lot variance. I mean, if you have a setback variance, then you need to show why you need the setback, and the board can say, throw some screening in or, alter your plan somewhat. So I could ask Alan for more information on that if you have any, but I mean, the information I've gotten from, I didn't deal with it in the borough since I've been at the township. It's been a heavy drain and all the tear downs that are occurring lately on the board. And it ends up with the neighbors being frustrated, the board being frustrated, and the applicant getting an approval.
Because, I think it would be a big improvement if the zoning board could impose conditions. I'm just making sure that they can't. Because maybe...
The issue is without having a plan of the house, there's not a whole lot of conditions that they can impose.
It's
a hardship variance.
Screening, perhaps.
Yeah, but when they,
Screening, say,
they
it's one
don't
of the-
because
one of
you don't know where the house is going to be located, and if the house is meeting the setback, that sort of says, do you really need the screening when that's what everybody else's setback is?
Yeah, the other point is that if this were a complying lot, there'd be no review and no conditions, so you'd be treating those separately, differently, which there's a basis for in that it's not complying.
Well, right, why even have the minimum if, like, why do we have the minimum lot size? Couldn't we just say, no matter what, if you have the setbacks, you can build?
I guess you
Isn't
could
that
if
what
you
we're
want.
doing here?
We have a minimum to try to establish a pattern for each neighborhood in terms of what the lot sizes are and whatever, but there are lots that just don't meet them, and that this is the case where, as Derek said, the zoning board deals with it at least once or twice a month. They meet monthly, and they're not really able to do a whole lot with them, so it's not a good use of their time, it's not a good use of the public's time coming out when there's very little that can be done. If there were a setback variance, that's where they really have more control, and that's typically when they would say, you know, can we increase the screening to offset this? Here, when you have lot area, lot depth, and lot width, and it's locked in, and the neighbor's property is the same size, well, they can't buy property from the neighbor to make their lot larger or wider or longer. And that's the rationale in terms of why they're routinely granting them. We're just trying to, you know, free up some of the time of the zoning board and treat everybody fairly, because ultimately, if they deny a lot area variance, it's almost a taking, and, you know, we're going to go to court, and I don't think we're going to win that one.
Well, I'm sorry, because I know I approved all of this, but now I've heard a lot of questions about it, and I'm passing those on because I couldn't answer them very well. And one of them is, another question is, that the township does not have prevailing setbacks, and so, for instance, Harris Road, we just approved some lots that are non-conforming, right? Didn't we just approve, and so, those lots right now, if somebody comes in to build not, you know, with the setback that's a lot farther back, because that's how much they're allowed to have, they could, and it would look ugly. I mean, they probably would do it because they want more parking, because that's what most people do.
In that particular case, the applicant did agree to move the house back to a more prevailing setback, but that's something that maybe when we do the rest of the ordinance harmonization, that we could look at prevailing setbacks in the township, but, you know, from having it in the borough, when you have a street like Library where all the houses are 75 feet back, or one like John where they're 5 feet back from the property line, it works well, but when you get a street like Wilson or Westcott where some are 40, some are 80, and it's...
Yeah, I know.
I mean, that ordinance could use some tweaking just throughout the outliners, but, you know, we could look at that when we do the ordinance harmonization. So.
Well, and then the last question about it that is, you know, just recently there was one of these applications, and the applicant met with the neighbors before doing this and made some concessions, and that won't happen anymore, right? I mean, that, because they won't have to. I mean, maybe that was just a very isolated, or that was really rare, but...
If that's something you want to preserve, then recommend we don't adopt it. I mean...
I know, I'm sorry, because I didn't really think about these things.
This actually came from the zoning board chair
I just
saying we're spending a lot of time on something we're routinely granting, but from a staff perspective, if you don't want to change it, don't.
Okay, any other discussion? Okay, is there anyone in the public who wants to speak to this? Yes, ma'am. Okay. Give us your name.
Hi, Virginia Kerr, 124 Jefferson Road.
Yeah.
And I am one of several people who objected in one of the isolated lot cases that the zoning board...
Ms. Kerr, I don't know if you were present, we talked about swearing everyone in for everything, so I'm going to ask, to the extent you're providing testimony, do you swear or affirm to testify truthfully?
I do.
Thank you.
All right, so I'm familiar with the zoning board's apparent policy of routinely granting variances in undersized lot cases. I happen to have a very strong opinion that those variances should not be rubber stamped because the lot size requirements are part of the legislated zoning. And under the municipal land use law, when somebody wants to build and to get a variation from the legislated zoning, the zoning board is supposed to find, first of all, hardship, which may be very easy to demonstrate in these cases, but it's supposed to find hardship, and it's supposed to find that the proposal will not have a negative impact on the zone plan, and that will serve the public good. And I actually feel that when someone comes in with one of these applications, the actual plans should be presented. The zoning board doesn't believe that, and apparently believes that if all that is being requested is a variance on lot size, there really isn't anything to talk about. It should just be granted. And I think that's inconsistent with the municipal land use law. But, and I don't think that this particular ordinance before you is a good idea. It may have been a good idea. I mean, it apparently has been the practice in the borough, but as Councilwoman Krummeler said, there is a difference. The borough does have a prevailing setback policy, and there is not that policy in the township. And in the neighborhood I live in, which was part of the first subdivision of Princeton, was developed beginning in around 1919, all of the setbacks were determined by a scheme of covenants. So we all have setbacks that are much farther back than the 25-foot setback that is in the R8 zone. It's a 25-foot setback. So, for example, with this ordinance, if somebody were, if you are relieving owners of having to come in to get variances, it would be possible for a developer to come in and decide to build a house that's 15 foot closer to the road than other houses, and that would look bad, and I think that's inconsistent with the master plan, which says that one of the things that we want to do is preserve the existing character of our neighborhoods. So I don't think we should come up with an ordinance that would in any way incentivize or give people the opportunity to build something that just stands out like a sore thumb. I also think that this might incentivize tear-downs, which are going on quite frequently, and the variance case that I and others were involved in recently has to do with a Toto house on Harris Road. It's what happened with that house, David. There were two lots. The Toto family had an oversized lot. They went to the planning board. They got a subdivision in order to build on one half of that lot because it was undersized. They got a variance for that. And then the property was subsequently sold, and now the Toto house itself is being torn down on a lot that's undersized, and the variance has just been granted to build a house, a new house, to replace the Toto house on that lot. And it seems to me, I mean, this very permissive policy essentially would incentivize tear-downs. It is not necessarily what Princeton ought to be doing at this point. So I think it should be reconsidered. Thank you.
Thank you.
I'm Chris Tarr from 93 Overbrook Drive. 93 Overbrook is an I'm sorry.
Mr. Tarr, do you swear or affirm to testify truthfully to the extent you're providing testimony?
I do. So my lot is undersized, and I went before the zoning board for this same lot area variance. It was another waste of money and time, even for somebody who knows how to do it and does it for other people. And before that board every month or every other month with these applications. I'd love to keep doing them, but I think they're wasteful of everybody's time. You establish that you can't buy land from your neighbors and that you're going to comply with the FARs and so forth, and you go home. It's just that the board should spend its time on more important cases, I think. David's case is one that would come before this board, and I've brought a number of applications for undersized lots. You need to subdivide those two lots, which have been merged together, by showing that the smaller lots would be more consistent with the neighborhood and the other lots in the neighborhood, and this board has approved such subdivisions on a number of occasions. And finally, to comment on the private restrictions, they are numerous, they are widespread. Many of the lots that are closer in toward the borough. My lot has a 50-foot front yard setback, even though the town setback is 25. And you'll find that the title insurance people demand that you honor the private setback restriction in your deed. So there's a 40-foot setback on the one that she mentioned, and mine's 50. They're honored, and my point is, the borough had a very good system. They treat these administratively. And by the way, at the same point in time, they begin to look at the house plans administratively in order to determine whether they're appropriate for a building permit. So I think the township should follow suit. I've seen the exasperation that the zoners feel when they get 2 or 3 of these in a row at a given meeting.
Okay, can I ask you a question? What do you think about the requirement to submit plans if we required?
Again, in my case, I had a lot that was slightly undersized. It's understood, and you're told several times over that your house must comply with the setbacks and the height and the FAR. It's customary, and I did it myself, went and visited the next door neighbor either side and the woman across the street, showed them the plans. I mean, you're foolish not to.
But if you didn't have to go to a variance hearing, you wouldn't have had to do that, right?
You could provide that even if it's administrative, folks have to visit with their neighbors if you feel that that's suitable. The point of it is that you have rules. You have an abundance of rules, and they must be complied with. I've been before the board where a neighbor said, well, I think that house is unsightly. Well, then what are you going to do?
That's what we're hearing from all the residents, that there are a lot of unsightly houses, so frankly, that is something that we're worried about.
Well, but that's in the eye of the beholder, and I think the zoning board has, as I recall, one of the rationales years ago from the township was they didn't want to deal with aesthetics. That was not the substance of a lot area variance to whether the house is sightly or not.
But what about in keeping, in keeping with...
It's a lot area.
Preserving the character?
No, the courts say if your lot's too small and you guys say you can't build anything on it, or you can't build that house on it, they're going to bring a takings case.
But what about, doesn't the master plan call for preserving the character of neighborhoods, and how can that be done without seeing the plan?
Yeah, but it's not whether you like it or it's unsightly. That's right. Beyond the scope of any of the boards, including ours.
No, I understand that, but there is something about being in keeping, isn't there, with the neighbors?
Ann Neumann has been talking a lot about the desire to get form-based zoning in Princeton, which would allow you to control a little bit more of that stuff. Until we do that, it's a moot question. We don't have that ability to look at that stuff. And
Can we finish the...
Yes.
I'm Charles Conley at 702 Prospect Avenue.
And so, to the extent you provide testimony, you swear to testify truthfully?
I do.
Thank you.
When this ordinance was first presented to the council, it was in conjunction with an ordinance eliminating the proportional increase in floor area for undersized lots. And I think if this could be recoupled with that ordinance, that was shelved, If it could be recoupled, then they could be taken together. I think to answer Councilwoman Cromhiller's point, the main problem with building on an undersized lot right now is that you can build an oversized house on it because of the proportional increase in the FAR. And there is a proposal to eliminate that, and I think this ordinance should be coupled with that and only put forward with that other ordinance in effect. Thank you.
Thank you. Anyone else? Yes.
Yaina Moore, 19 Green Street. I swear to tell the truth, so help me whoever. Thank you. First, I guess I'm a little worried when the term harmonized zoning is used in this process, because it assumes that we're all singing the same tune. And every neighborhood has a different character. As Ms. Krimler began to point out, that most residents in the town, in the neighborhoods within which they live, want to maintain some kind of order. That doesn't mean every house has to be the same, but what a blanket code attempts to do has different impacts on every neighborhood. Now, for example, I'm going to work with the Witherspoon Jackson neighborhood, because when I was a member of ZARC, there was attempted on several occasions to do a form-based zoning which took into account the majority of the site and lot sizes, then being about 95% non-compliant. And what was stressed by residents was to make those the standard, make them the maximum size, make contextual zoning, as you also pointed out, Ms. Grimiller, with regard to the prevailing setbacks, a matter of the character of the neighborhood, and not deal with whether it's 10 feet back and the porch being included, for example, one of the considerations of a code, in the square footage of the house, because it's actually a sort of an appendage, a part that is actually and could be possibly in closer to the setback than allowed or within, and forms the character of the neighborhood. I mean, I think what much of the effort towards going to a historic status is to try to therefore rewrite the zoning for that neighborhood, which I'm sure everyone else, this is why you get the flurry of historics, tries to do. And until, as Mr. Cullen mentioned, a form-based zoning is taken into account for every neighborhood, these kinds of attempts to be blanket are rife with problems. They're just not, it's not this easy. And we worked on it 5 or 6 years ago. Even had, I believe, Lou may have remembered, drawings showing setbacks, roof lines, cornice lines, porches, non-porches, detached garages, attached garages. But it really is a neighborhood-by-neighborhood approach. So I'm disappointed, I guess, in the process and what this, as a sort of blanket coding attempt, is going to do. Thank you.
Thank you very much. Yes, Mr. Driscoll.
Paul Driscoll, Harris Road.
To the extent you're providing testimony, do you swear or affirm to testify truthfully?
Yes, I do.
Thank you.
Basically, I would like to say, that I disagree with what people are saying, that the size and scale of the house, that the beauty of the house is totally subjective. There is size, scale, and relativity. And I agree with what Ms. Moore said, that there is the issue of the character of the neighborhood. And I basically agree with her that although the houses may be different from each other, that size and scale and streetscape really needs to be maintained. And if you have these small lot, if you eliminate these small lot variances, you're not going to give the neighbors a chance to come in and comment on how they feel about it. Now, I live on Harris Road, which when I had to put on an addition, I was told by the planning board at the time, because I asked, why is this necessary? Because it was very inconvenient for me at the time, and the architect had told me that he didn't think it would be necessary because I was just extending the existing line. I was told by the planning board, and this was about 20 years ago, that they did not want me to change the character of the neighborhood and that I lived in a close neighborhood, implying that what I did impacted my neighbors. And although it was very inconvenient and I lost the bid that I got from a builder and had to go with a more expensive builder, in the end I was happy to do it because I believe that preserving the character of the neighborhood, I mean, I wasn't happy to do it, but I thought it was the best thing because I thought I was being fair to my neighbors, and in turn, I want my neighbors to be fair with me. I do think these bigger houses can block the sunlight from a house. It can change the amount of privacy you have. And I have heard of cases where neighbors have come in and said, could you change where the position of that window so it doesn't look directly into my bedroom or into my family room? And people have done it. So I do think these variances can serve a constructive purpose, even though maybe legally the developer doesn't have to do it. If he wants to be thoughtful of his neighbors, it gives them a chance to discuss it openly. When you eliminate the variance, there's no conversation. And I think that's very important because I think if you live in a close neighborhood, you want to be considerate of your neighbors. You do want to get along, especially if you plan to live. And most people who come to Princeton very often do live there for a long time, particularly in these smaller lots. So when it was said earlier that it's these isolated lots, but the ordinance needs to be adjusted because now that could be applied to lots in the smaller neighborhoods, the smaller lot neighborhoods. If you have a lot which is 5 acres, maybe it doesn't matter what you do on that lot because you can screen it out, you can set it far back from the road, and people are less aware of it. But in a smaller lot, you have less room for landscaping. And so therefore, I would vote that this ordinance be changed or rewritten to be more realistic to the needs of what homeowners are talking and what Councilwoman Ms. Crumler has been saying, that people are saying, well, it's unsightly. They don't mean necessarily that it's ugly. They mean it's completely out of scale with the neighborhood that they're living in. And I think that is a standard value that's fairly objective. I mean, whether it's a ranch or whether it's a two-story, I agree, some people might say one's ugly and one's pretty. That's subjective, but size and scale is very important, and I think we've lost that perspective in Princeton. And I'd like to suggest that the planning board work on a way to maintain that. One example that I'd like to give is the newly formed combined lot in Harris Road, which you just spoke about earlier on your findings of fact. That lot has setback lines which allow for a much larger house, and it even overlaps, and it's on the final plat du jour, it even overlaps on the part that is not supposed to be developed, which is in the deed. Well, if a new developer buys it and he sees those setback lines, he submits a variance, but then why are the lot lines there?
That's been corrected, that as one of the conditions that were required to redo those setback lines, just so the record's clear.
Oh, that will be redone?
It is redone.
Okay.
It was in the, it was in the agreement.
Okay, so now that portion of Lot 11 that's not supposed to be developed, is it up to the neighbors to come back and see that it won't be developed? Because that's confusing to
That's
me.
a different issue.
Because then that becomes a legal issue.
It's a zoning violation, just as anybody else who violates a zoning provision, there's enforcement.
Would they need to hire a lawyer then?
And the zoning officer would...
Sorry? I mean, what I could see is that somebody applying for a variance and maybe getting the variance somehow, because according to what you're saying,
You talking about the lot on the corner of Harrison and the Avalon Bay? Is that what
yeah,
it is?
Harris and,
That would be more than a variance. I
Avenue.
mean, it's not buildable. It's an ordinance. It's ordinanced in the code that lot cannot be built on. So that would be a big variance. I mean, but
Anyway, I think that you've made a number of points, and is there anyone else who wants to speak to this tonight?
well, the setback lines are going to be changed then on that particular lot.
That's correct. When that subdivision plat is filed, that setback line will not be as it appeared in the presentation.
Okay, thank you.
Thank you.
Mary Clerman, Harris Road, and I swear to be honest in any testimony. Is that how it goes? Do you want to say it, or do I get to say it?
I wasn't
Very,
here.
very well, but
Yes.
you'll have to speak into the microphone.
Yeah, it's a challenge for all of us, and I appreciate your efforts.
To the extent that you're providing testimony, do you swear or affirm to testify truthfully?
I do.
Thank you.
I had another question about Lot 11. My understanding is that it's deed restricted, but that the town can't enforce that it has to be... I think I spoke to Mr. Bridger about this.
I'm sorry,
You can't hear me? I can't...
No, not you, the microphone.
How's that? Is that better?
If you get closer and speak loud.
I'm on the mic.
Okay.
I'm leaning on the mic. Okay, all right. So I spoke to Mr. Bridger about the Lot 11, and my understanding was that even though it is deed restricted, that the town is not able to enforce the way that the lot is treated and the way that the lot is maintained, and that if somebody buys this property and wants to build something on it, or wants to put a bench or a playground equipment, that it's up to the neighbors to complain about that it's nothing that the town can do anything about. Is that correct?
Did you get that, Derek?
There's an ordinance in the code that prohibits that lot from being built on. If it's being built on, please call me and I will enforce the ordinance.
So, okay, and then the other question is, how about the maintenance of that lot? Who's responsible for the maintenance of that lot?
Mr. Chairman, I think that we discussed that when we were approving the findings, and I think that you can call Mr. Bridger and ask him about that. Right now, we're going through this ordinance, and I thought that you wanted to speak to the small lot portion of it.
Okay, I'm sorry, so you'll be returning to that? Okay, you'll be returning to the other, or are you finished with it?
I think that the other really was part of an earlier discussion this evening, and you can call Mr.
Because what I
Bridger's
heard,
about it.
I'm sorry, what I heard you guys say, I think, wanted to say, was that the discussion was of the fees on Lot 11, or...
No, we're not discussing Lot 11 per se.
Sorry, thank you.
Okay, is there anyone else? Yes.
Heidi Fichtenbaum, 38 Carnahan Place.
And to the extent you're providing testimony, do you swear or affirm to testify truthfully?
I do.
Thank you.
I'm just going to add my voice, probably repeating what others have said, but I think what you're seeing is that there's real concern in the community, in this room, and other people who have asked questions, perhaps to you individually, about sort of planning in general in Princeton, and that's what this is. This is elevating that whole discussion, and different neighborhoods are very different, and how they get built controlled by the zoning ordinance, which is setbacks and bulk requirements, which is, in my view, can be actually a very kind of crude way of determining, how everything is getting built. And especially in a place like Princeton where the land resources have really diminished. So there's a lot of development pressure. And so that's what this is all sort of bubbling to the top to say, is that the way relaxing what we have is causing concern. Not that the process is not cumbersome the way it is. It probably is, but it's causing concern because people are seeing development that is really inconsistent in the town. And in some places, it is maybe somewhat controlled by the setback. In other places, it's actually more controlled by parking and nothing to do with setbacks, how much you can build on a lot. So, and what this means is nobody has a sense of what could really end up on a lot. And all of a sudden they realize when a house comes down or something like that, that something really totally out of character. And so, these setbacks and the bulk ordinances don't necessarily help describe a typology, right? And I think that's another thing. That's what people are trying to talk about. And when they say form-based zoning and all of that, that's really what that's driving at. It's maintaining the character of the neighborhoods. And that is something that is in the master plan. But we know that it's only these zoning ordinances with their numbers that are the only thing that you can hang your hat on when it comes time when a developer walks in to, put a plan before the planning board or zoning. And so I think that's really concern. And I would also challenge you to think a little bit about what the word isolated means. Because you can write that word in there, but if you don't have a really tight definition on what isolated means, it's going to be really hard to decide that this lot is an isolated one and some other one over here is not an isolated one. And I know that when I've had to do things on my own lot or for clients, I have definitely been held to the standard of if I needed a variance, of showing why there was a hardship, showing, even for something as small as a shed in my backyard, why there was a hardship, how it did not undermine the zoning ordinance, and what was the beneficial aspect of that for the community. So I don't know why we would decide that is not a good standard. And if we're going to try to address a problem of something that has become a burden for the zoning board, then it needs to be really well thought out. And I think that most importantly, our town council and our planning board need to be thinking very deeply about planning in Princeton. And that's what this is, that's what's resonating here. Thank you.
Thank you. Is there anyone else? Okay, well, hearing none, let's go back to small, isolated lots. And, yes.
I have a question for Mr. Bridger. Actually, what is the average lot size of these properties to whom the administrative variances are given?
They range myriad of lot sizes, from the smallest lot size in the township to the largest lot size. So they're all over.
So it depends on the individual request to the zoning board that determines, the individual request to the zoning board determines whether or not that variance is approved.
Not really. What you're really hearing is people, I think, complaining about the size of the house that's being built. This exception only deals with the lot area, the lot depth, and the lot width, all of which are pre-existing conditions.
Right.
They're part of the neighborhood, the lot is.
Right.
Whether it had a ranch, or a tiny house, or a big house, doesn't really matter at this point. What they're suggesting is, it's an existing lot, it had a house on it, most likely. The house got knocked down, chances are it's going to be a bigger house. They're not required to submit a building plan, and they don't.
Right.
Because they're not asking for an FAR variance or a setback variance or a height variance. They're saying, I'm here because my lot area is 20,000 square feet, the ordinance requires 21, or it could be my lot is 20,000, the ordinance requires 40,000. But guess what? My neighbor has a house on his property is 40,000, that's the requirement. The gentleman behind me has the same thing, they can't sell me any land. The woman on the other side also has the same size. Mine is an isolated lot. It had a house on it before. We are making them go and get a variance. We currently do not require building plans, and part of that is they're not going to prepare a building plan until they know they have a buildable lot, and they're going to comply with our bulk requirements. So it doesn't matter whether it's a 3,000 square foot lot in a 10,000 square foot neighborhood or a 5,000 square foot lot in a 6,000. It's an isolated lot. It's part of the community. And I agree with people. I understand, and we tried to do some of that with proportional FAR. Either we do a form-based code, or you attack FAR with a house cap size, which has not been a popular thing to do. It's been extremely difficult, as you all know, when we've tried to impose either a change in FAR or a cap. So this is only about that individual lot that's part of the neighborhood. It's not allowing somebody to subdivide the lot into two. It's just simply saying it had a house on it. The house is no longer there. The ordinance requires that you have a certain lot area variance. This would exempt that.
So the house could be, and when they finally bring the plan in, it could be a bit larger, bigger than it was, than the
Oftentimes
previous
it
house.
is.
However, it matches the neighborhood.
I don't know if it matches the neighborhood. It complies with the zoning, and that's the issue.
That's what I mean, the zoning. The zoning
Right.
is
What you're hearing
what
people
would
say
be
is maybe we
allowed.
need to revisit some of those requirements. We've tried to do that in neighborhoods where people have said we should do that, and it just hasn't worked because the neighborhood ends up splitting as to whether or not they want to impose additional restrictions. We can always revisit it, and what I'm hearing more is the issue is more the size of the house. It's
Right.
not the fact that there was a house on it before and that was out of character with the neighborhood. We're really talking about we would like to be able to review the house that's being built.
Yes. Alan?
Lee, just for clarification, you keep referring to there was a house on the lot.
Most of
This
these,
would
that's the
apply
case.
even if there were...
If there were not.
Just for clarification.
Right.
All right.
Yes, Mr. Cohn.
I think I just want to comment that if the decision is not to go forward with this, it would seem on a basis of fairness that you would want to make the reverse change in the borough. I mean, or the former borough. I don't see why, as a consolidated municipality, some people, some citizens should be required to go for a variance to develop an undersized lot, and others should not. And unless there's a justification given for why it's different in the former borough than it is in the township, I think you have to reconcile these one way or the other.
Okay, any other comments?
Well, so one of the things I'm struggling with is it seems like what we have now is giving the illusion of control to the zoning board and to the neighbors because of the way it's set up, because whatever is brought before the zoning board, they feel that they're just not given enough information to say anything but approve it. I mean, what we're hearing from some of the public tonight, and this is what I don't quite understand, is the decision to say you don't have to bring plans for the building, is that our decision, or is that state code that says that you can come to the zoning board with just the idea that you want to build something?
I believe it's not a legal requirement that if you build a house that complies with the zone, you don't have to bring plans. But, I mean, if you want to go, you're going in a completely 180-degree direction now. I mean, I just don't know it's different when you have a site plan for a shopping center. You can say, narrow the driveway here, add more parking spaces, but on a single-family home, I'm just not sure what what rights we have to call for that information. I don't know, Alan, if you have any insight into that, or?
I guess there are a couple of things going on. Number one, if it were just a complying lot, there's no site plan review requirement for 1- and 2-family residential properties. So that anyone who owns a lot that's complying can apply for a building permit without site plan review. So the question here is, does the fact that you need a variance allow for an enhanced review? I guess I haven't researched that issue and don't represent any zoning boards, but I think it's probably the case that you could require plans for that. It might be bifurcated. As you said, you may not want to come in with plans if you're not going to get approved. There's a process where you're talking about a use variance, where you get the variance first and then the site plan second. I'm not sure what that adds, because again, the issue really is you're trying to just deal with the lot issue. So maybe, as I say, I'm not sure that is the law, but apparently that's what locally has been enforced.
But that sounds like it might be actually go a long way toward what we're hearing from residents. If the zoning board is saying they're getting 2 a month of these and then they feel like they can't do anything, that's causing a lot of frustration. So if I'm sorry, zoning board, but if we could require plans, then that might improve the process, not from making it fast, but from, there would be just some negotiation maybe, putting the screening or moving the window, like someone said. No?
I think you're really reaching the point where if you're not comfortable recommending the ordinance because of the comments you've heard, you might want to advise council. I'm sure many of the people who spoke tonight will come to Monday night's meeting as well.
I guess my feeling, though, is like if we're not able to require the plans in any way, then I do feel like it's a waste of time, because if there's an illusion there, and so it doesn't make sense. But if the answer is we could require plans and make that a process that's not an illusion, but that there would be a real decision, then that changes my feelings about it. So I guess it depends.
I think it would still be an illusion, though, Liz, because if you make them bring the plans and the plans completely comply with all of the bulk requirements, on what basis are you going to ask them to make a change?
Yeah, the problem is, what are the standards? If they're plans, under what standards are you reviewing them? Whether you like the house or, because it's going to be complying with the requirements. So I agree with David.
But it's kind of like the green checklist, just having the meeting and causing the people to come in and confront the board and their neighbors. Mm-hmm. Don't you think it might improve the process?
Well, no, I don't.
If nothing is going to be gained from having them pay money to get an attorney, an architect, or whomever, planner, to bring plans in, why do it?
But we do know that just like what Ms. Fichtenbaum was saying, when she prepares for these variances, she has to, tell what the hardship is. She has to say what the what the impact is on the zoning plan. It has to be a positive. I mean, it can't be a negative. I'm not sure about the legalities.
I think that was Ms. Kerr who was...
Well, no, the victim, I was saying that when she was preparing
Depends on the
plans.
kind of variance
But
it is.
let me just say something about the philosophy behind this. 40 years ago, it was the philosophy that we left these things up to the zoning board, that it provided, as all of these people who've lived here a long time know, it provided a forum for the neighbors to come in and say something about it and perhaps massage whatever was done into something that was a little more compatible with what existed in the neighborhood. The real problem is that this is part of growing pains, that now we've consolidated. We have a much bigger load. We have one zoning board and not two. We have one zoning officer and not two. And I think that we have to look at ways in which we can work more efficiently. Otherwise, we're going to have a municipality that just bogs down in the same level of detail that we had before. I'm not sure that all of these things that we've proposed are going to give that level of efficiency. And I'm very dubious that we can promise that the zoning board would constantly go on massaging these things. They simply don't have the time anymore. So if you don't feel that this is the way to make things work more efficiently, then let's say that it needs more work and move on and look at some of the other things. So what will it be?
I mean, I personally would like to support going ahead with this change for the reasons that I've said. I think it's a fairness issue between the former borough and the former township. I think that any review that is done has the illusion of having control when it really isn't there. I think that to give the neighbors an opportunity to come and speak when coming and speaking will not have any result is actually an exercise in frustration, not an exercise in letting them feel empowered. So, unless we want to require that plans be submitted and we want to establish a basis on which to review those plans where we can actually reject them, I think that we should go ahead and support this change to the ordinance.
Is that a motion?
Yes, it is.
I'll second.
It's been moved and seconded. There's no further discussion.
This is to recommend adoption by the governing body with the understanding that these are single lots, sometimes called isolated.
Okay. All right. I think we ought to call the roll on this since there's been so much discussion.
Ms. Capizoli?
I feel a little conflicted. I mean, I do feel that historic preservation really is the only venue where the character and the appropriateness of a building can be openly and clearly discussed. So I understand the quandary that you're in. On the other hand, if there is a way to require plans to get people to negotiate, I don't know, I'm looking at Alan and he's shaking his head like, no, I don't.
Well, I'm saying requiring plans without adopting a set of standards, you're back in the same issue.
So I don't know, I'm just going to say no because I feel like this is still unresolved.
Mr. Cohn?
Yes.
Ms. Cronmiller?
No.
Mayor Lempert?
I guess no at this point.
Mrs. Trotman?
Yes.
Mrs. Ullman?
Well, I'm conflicted and confused. I'm going to say yes for the whole efficiency notion for this time, but boy, do we have a lot of work to do.
Yeah.
Mrs. Gunning?
I think I agree with Ms. Ullman. I'm going to say yes, but I think there's a lot of work to be done on this.
Mr. Quinn?
No.
Mr. Williamson.
Yes.
Motion carried.
And the motion is a recommendation to governing body, which will have its own hearing on determine these issues as well.
And Ms. Krummeler and I will do our best to convey some of the concerns that were brought up here, too.
But there will be a public hearing, so
Yes.
the public will be free
Do you have the
to...
date for that, Liz?
Yeah, I believe it's on December 21st, unless, do we have it at this meeting coming up? On the 7th? No, I can't remember. I don't, oh, we do. Oh, it's on December 7th. Sorry, December 7th, Monday night.
All right. Mr. Solo, do you want to move on to the next one?
Thank you. The fourth ordinance on the agenda deals with reconstructing a building to the prior FAR, and this is just in the former Borough Code. Section 17A 403 permits structures to be reconstructed to an existing FAR, even if the building exceeds the current permitted FAR and bulk requirements without board approval. The proposed ordinance would delete this provision, thus ensuring a hearing on the size of a structure if it is rebuilt to something that's larger than what the zone permits.
Okay. Yes.
I don't know if there are questions on that one. It's pretty straightforward. We haven't had many applications on this. I think we've had maybe one in the last 10 years. Typically, zoning tries to bring buildings into conformance with what the zone is. This sort of works against that in that it allows for, if there's a fire or if it's demolished for other reasons, to be rebuilt to a larger than what would currently be permitted. So we were, in going through the ordinance and looking at things that address the size of a house or non-residential structure, we recommended removing this.
Okay. Comments, anyone?
I just want to say I support this.
Anyone else?
I also support it.
Anybody want to say something expanded on this?
Well, I mean, it relates to the conversation we had with Avalon Bay a couple of meetings ago, where we explicitly refused to give them the right to rebuild. You know, I will point out that it's not always about a house being bigger. Sometimes it's just a setback variance. The house may be the same size or smaller, but may want to be close to a lot line for whatever reason. But I think that basically what we're saying is if you have a good reason for doing something that's not according to the zone, come and get the variance.
Okay. I'm surprised. Is there anybody from the public who wanted to speak to this ordinance? No? Alan, any comments? All right.
Just that we didn't deny Avalon Bay. They withdrew their application for those
Right,
variances.
but we discussed this specific issue.
All right, if there's no discussion, then maybe someone would like to make a motion?
I'll move it.
I'll second.
Okay, it's been moved and seconded. All those in favor?
Aye.
Aye.
Opposed? Carried. What? Yes, this is to recommend that it be deleted, right? Mr. Porter? Okay.
Okay? The fifth ordinance on the agenda deals with lot frontages in the former township. The existing township ordinance permits a lot frontage that's often half of the lot width requirement. The planning board has had a few applicants that have taken advantage of this provision, which results in a subdivision that could change the character of the neighborhood, result in uneven lot lines, and result in houses being placed in unusual positions. Let me just to refresh everybody's memory, this is a good example of what happens. That's a conforming subdivision on Valley Road where the lines zigzagged. They placed the house all the way in the back and the garage in the front. It had no variances. Our alternative was to grant a variance to have two narrower lots. With this provision, what we're recommending is that within the R1 through 9, the RA, the RB, and the RH, the lot width would equal the lot frontage requirement, so you wouldn't have that condition or be in a position where you say it would be better to have two narrower lots than one like that that would completely be out of character in terms of the neighborhood. There's a provision in there that if there's a curved alignment with an outside radius of less than 500 feet, the minimum distance between lot lines measured from the street line shall not be less than 75% of the requirement. So it allows for a little bit smaller, which makes sense on the curve. And I think the visual aid shows you exactly what it is we're trying to address. I don't know if there are questions on that one. It's probably a little bit more fresher in everybody's memory.
Right, and could you also comment on these things that are not flag lots but have a sort of kick?
Yes, on the back of that is an example. By definition, a flag lot has a 50-foot wide pole going back to the flag portion in the back. We've had numerous applications where, because the lot frontage is half of the lot width, there's a little bit of a boot along the street frontage, so they meet the lot frontage requirement, and it looks exactly like a flag lot, but because it meets the lot frontage requirement, by definition, it's not a flag lot. If the flag lot provisions require a slightly larger lot to provide protection for the surrounding neighborhood, so this would also eliminate those type of subdivisions, which we haven't seen a lot of, but we've seen a few.
Okay. Any comments on this one?
I support this.
So do I.
Yeah, me too. Anyone else? No? David? No? All right, let's see. Is there anybody here from the public who'd like to comment on this? No? All right. If there's no public comment, let me close that portion. Would someone like to make a motion, if you're all?
I move to approve this. Julie Capizoli. I'll move to recommend this.
Thank you, Julie. Any second?
I'll second.
Thank you. No further comments? Okay. All those in favor?
Aye.
Opposed? Carried. Now, good. Mr. Sello, do you want to do the definitions and floor area ratio?
Yeah, I'm going to suggest a change to the ordinance a little bit. What we're passing out will be some changes on page 2. This is a result of some discussion with the board's attorney, Alan Porter, in trying to clarify some of the ordinance. But first, let me speak generally about what the ordinance does. This amends definitions for attic, basement, floor area, and floor area ratios and stories. What we've done is for the attic definition, you're seeing what this shows you on page 2. Underlined is what's in the ordinance, and we're suggesting a change to simplify the attic ordinance by defining it as that part of a building that is immediately below and wholly or partly within the roof framing, which is similar to what's up above, and then we would take the remaining part, which deals really with whether it's FAR or not, and put that in the actual floor area definition section, which is down below where you see highlighted in yellow that change, which would be that the attic space in a single-family residence, and Alan pointed out to me, should be really a single-family or two-family residence, because that's how in the borough it was worded. Attic space in a single-family residence with a height of 7 feet or more, measured from the finished floor to the roof rafter, shall be counted as floor area, except for an area that is less than 1/3 of the area of the floor directly below. Attics areas in a single-family or two-family residence with a height of less than 7 feet in height, measured from the finished floor to roof rafter, shall not count as floor area. The 7 feet is the critical component because under the building code, that's what's a habitable space. The rationale for excluding the 1/3 was to allow people to at least still have a taller roof, which would look better with some of the buildings or the homes that are being constructed, and allows for that peak, and then we wouldn't count that per se, but if they have everything raised up, we wanted to capture most of that. The ordinance also amends the definition for a basement from 6 feet 6 to 7 feet, because we wanted to track the building code for habitable area. Mrs. Ullman asked me to point out changes from what Zark saw. One of the changes that the council made was, originally we were taking out as an exemption from FAR garages, sheds, and roof porches. Council agreed to take out the garages and sheds as an exemption, but left in the roofed porches as something that was desirable, and you'll see language in there to permit an exemption for 200 square feet of a roofed porch, open on one side. Did I cover everything? Oh, and I think Story was also modified from 6.5 feet to 7 feet, again, tracking the building code. I don't know if there are questions on these or on, I apologize.
Just to be clear, the highlighted, which was changes, they're changes from the ordinance as introduced.
Correct, as introduced, and we would recommend that if the planning board sees fit, that you recommend to council. And talking with Alan, it seemed to make more sense to keep the floor area exemptions all in the floor area portion of the ordinance as opposed to in the definition of an attic. I've talked to the municipal attorney who agrees it's not a substantive change because the intent is the same as what we were doing, and then the language modifications are just clarifications of some of those.
Lee?
Yes.
The part about the porches, I don't have a strong feeling about it, but you all did put it in creating the change to the ordinance, and I'm wondering why, if there is an opposing argument to taking it out that I haven't been able to think about.
Well, we originally recommended taking out anything that was an exemption to FAR, so we were giving exemptions for sheds and garages and porches because it just resulted in a larger house, and we were trying to respond to some of the comments about the houses are getting too big, so we said take out all the exemptions. At the council meeting, I think council heard from a number of residents that they didn't want to have to make a decision between a porch and some additional living space, but that the porch is very characteristic in many neighborhoods as a element of the house, for lack of a better word. So they were convinced that we should still provide that exception so that people don't have to decide between 200 square feet, that's a 10 by 20 room, or a front porch. So, I mean, I think that's... the mayor or Jenny maybe could comment more, but I think that's why they decided to keep that exclusion after hearing from the public that that was still desirable. The feeling was the garages, while everybody has them, they didn't want to pull that out and provide that exception anymore. We found in the borough where it was a slightly different language where we were exempting it only if it was a detached garage behind the house. We weren't getting any of those. Nobody was making that decision. We weren't aware of that many people who were making a decision, front porch or extra room in the house, but based on the comments we heard at the introduction of the ordinance, there were enough people that convinced council to put that in.
Okay, so I have to say I watched part of that council meeting on television, which was video, which was above and beyond the call of duty. I just want it to be said right here.
Riveting TV.
Right, yes, okay.
But there was a concern that porches can be filled in, porches can be turned into actual house space that was countered, I mean, that view was countered at some point, but does that happen?
It does happen. It's more of a problem when they don't get a permit to do that. When they do come in for a permit, Derek can speak more to it, but he does review those. He does do a recalculation of the FAR. So if they come in for a building permit, the building department sends them over to zoning. Derek looks at the existing house plans, what's being proposed, does a new calculate. Am I saying anything wrong? Does that calculation, it gets caught. I think where somebody has a screened-in porch, and then all of a sudden they put in windows and don't get a permit, we don't know unless a resident or somebody complains, somebody tells us about it. And I think at a staff level, we agreed. We thought if people are making that kind of decision, having the porches is a plus. We were approaching it originally by saying, let's take out everything that adds to the bulk of the house, and then hopefully we can come back at another time to address some of the comments you heard about FAR. That's a much bigger study, a much longer conversation.
And the same thing would apply to people digging out basements to make them.
Yeah, again, unless we know
That's a big game
about it.
in my neighborhood, is lowering the basement floor to make it habitable.
I should point out,
Actually, I mean, that wouldn't throw it into the FAR anyway. Just because the ceiling is taller doesn't push it out of the basement definition. It would actually you would have to raise the whole house out of the ground in order to make it not a basement.
David's correct. For basements, we don't, they're exempt anyhow because it doesn't add to the mass or bulk of the height or bulk of the house.
I was just going to add, to the extent that a porch is filled in, I guess the implication was if you didn't know about it, it was okay, but it's still enforceable, and if it created an FAR problem, you could deal with that from this enforcement level.
Right. I think there's a question down there.
Yeah, I just want to raise the issue with the garage, the loss of the garage exemption. I'm afraid that I think we need to think a little bit about the law of unintended consequences. My concern is that we're having a lot of friction right now as we try to implement complete streets in town because people want to park on the street, and that's competing with other uses like bike lanes and so forth. I think that if we eliminate the garage exemption, we're going to drive more parking onto the street, which will exacerbate that problem. I can't prove it, until we make the change in the ordinance. We won't know whether we're going to drive more parking onto the street, but it's a concern of mine.
Interesting.
Any other?
Just a question about porches. This is all types of, it covers all types of porches like, verandas and covered entryways and so on. And those would be recognized.
Yes, any covered porch with an open side.
That would be recognized as porches.
I think Jenny had a question, sorry.
Sorry? Yeah,
No, I was just going to comment that I supported this, and I hear David's concern, but I think it's just the same as anything else. People are going to have to choose between living space and their car, because we already have parking requirements, just like in the other, these other things that we're doing. There's other regulations that are...
As long as council members have the courage of their convictions to take away parking on the streets, I don't care.
Well, we're definitely not giving more parking on the streets.
Anyone else?
I just wanted to thank the staff. I wanted to thank both Lee and Derek for putting together this package, and I know there's a few more pieces of it too, but I think we've all been hearing the concerns in the community, and I just wanted to thank you for helping us to address those. And thank you to Zark too for the first go-round.
Okay, if there are no more comments on this one, would somebody make a motion? Oh, sorry.
Public.
Yes, sorry.
Charles Carney, 702 Prospect Avenue. I still am a little unclear about the one-third exclusion for the attic areas. So if I have a second floor which is under a Dutch roof and it's 80% of the area of the floor below, does a third of it get exempted from the gross floor area or not? It's all roof. The second floor is all roof above it. It's a Dutch roof thing.
Gambrel, yeah.
Gambrel?
roof. Dutch
The
colonial.
floor is nearly as big as the first floor.
It's not an attic.
No,
Second
it's
floor is not
The
an attic.
definition of attic's an attic.
because attic is any space under the roof.
But it's really big, and the question is, do I subtract a third of the first floor from that area before it gets counted to the FAR? If it does, I don't think it should.
Sure.
Yeah.
It's the second floor, typically.
I think our interpretation is that's a
That's
second
what's-
floor, it's not an attic.
That's the problem with those two atrocious houses
Well,
on Valley
I don't
Road.
understand the definition of attic then.
Yeah.
The definition of an attic is that part of a building that is immediately below and wholly or partly within the roof framing.
Because
If they have the ceiling, there's still
No, there's no ceiling. It goes up, down.
it's an attic.
Yeah. It's a
Second floor.
It's a second floor.
But it's also an attic.
Yeah, I have
Definition.
I have
We would
something like
consider it a
that in
second
my
floor.
house, too.
Okay, so if it is an attic, let's say it's a peaked roof, then but it's still half of the area of the floor below, is the whole half area get counted as floor area, or do I subtract a third of the floor below before counting it? Okay. Does everyone agree with that? Okay.
He wants to know whether he subtracts a third of the
I-
area below that.
I have one other minor comment. I would love to see the language deal explicitly with stairwells. Derek knows what I'm referring to, but there's been a change in policy in recent years about how a stairwell is counted towards FAR. It used to be counted as just once in a two-story house because obviously you don't have a second floor where there's a stair. But then recently, Derek started interpreting that as being counted twice.
For the landings.
Not for the landing, as though you had an entire second floor throughout without a stair going up, taking away part of that floor area. And it was a response, an understandable response to pressure from the community to try to make houses smaller. If that's going to be the interpretation, I think it should be in here, because right now the definition's a little bit unclear and can be interpreted either way, and I don't think that Derek should be in the position of having to be the bad guy. It should be a clear language.
Well, it's like any process of bringing two different organizations together. In the borough, I did not exclude stairs. When I started in the township, the practice was to exclude stairs, and I made the gut decision just to not exclude stairs. I mean, my problem is I get about 800 permits a year, probably a couple, maybe 100 new homes, a lot of additions, but I have to manually scale the plans where the architects have a CAD program. So, I mean, it's difficult for me to start taking out little, and this is, I mean, my intent is also to take the more conservative approach to scaling on the sizes of houses, because I think, I don't get calls saying, build more big houses. I get calls saying, why are all these huge houses going up all over town? So that's the approach I'm going to take. It's an interpretation. And in most cases, it's not a lot of square footage that you're dealing with that people are getting, but I'll be guided by the board.
Do we need to have specific language in there? I think that's what
Yeah, I'm
David
just
was saying,
asking for
was just like,
specific
can we
language. I'm
have
not saying
it to
to.
say that there's no exemption? I mean, do we have to explicitly state that there's no exemption for a stairwell?
Or would that be a big deal to do that?
Is that a material change? I mean,
I don't know. It's a minor point. I mean, it's been working the way it is, because neither ordinance really spoke to what you did with the stairways, so it was an interpretation of the zoning officer, and what you had was in the switch, they were dealt differently, and Derek has just sort of made the change. But, I mean, we're not talking about a lot of square footage that's being lost one way or the other. It's like
But if you're
30,
at the
40 square
margin,
feet.
it's important.
what's that?
If you're at the margin,
Just about
Well,
over.
every 95% of the plans come in, the maximum is the minimum. If it's a 40% FAR, it's 40%, and so.
Do you find when people are coming in, they're confused about the stairwell issue? I mean, are people...
Well, not the people that do a lot of work in town, they know that David, local architects seem to know the code very well, but you get a lot of guys that are out of town and they don't read it, and,
Right.
I kick most FAR things back once or twice before they get through my process, so, I mean...
Lee raised the question of if you implement that now, is that a material change which would require the ordinance? We noticed it's a new item, it probably would. I don't know how crucial timing is, but if you, then that issue should probably be held. And if you want to direct staff to address that in a separate amendment, then that would be the way to deal with it.
That seems like a good idea.
That would work, wouldn't it? Everyone? Okay, so I think that we've had a lot of discussion on this one. If there's no more, we need a... we just had the man in the red sweater. Okay. Does somebody want to make a motion? Yes? No?
Yeah, I'll make a motion that we approve the wording of this and pass it on to council with that.
The new wording.
Second.
Okay, and that's with the changes you've been given.
Yes.
Okay.
Second.
So I guess that's really technically an amendment request that supports the adoption of this ordinance with the changes that are recommended by Planning Board.
And which you received and which will be forwarded to council. Do you want to just call the roll on this so we're clear? This is a little complicated.
Ms. Capizoli?
Yes.
Mr. Cohn?
Sorry? Hear you.
Well, he's thinking.
Cohen is asking you for a vote.
I know.
Okay, go ahead, please do.
Yes.
Ms. Krummiller?
Yes.
Mayor Lempert?
Yes.
Mrs. Trotman?
Yes.
Mrs. Ullman?
Yes.
Mrs. Gunning?
Yes.
Mr. Quinn?
Yes.
Mr. Williamson?
Yes.
Motion carried.
Okay. All right. And I do want to thank the staff as well for all the work that this has involved. It's been really a lot of effort. Don't say move. You want to move for adjournment, right? Okay.
Move to adjourn.
All right. It's moved and seconded. All those in favor of adjourning, if you... All right. Don't start on that. I don't want to explain that to the board. Oh, well.